what's going on with me, Sage L. Everybody must know me as DJ Danger. Originally, one and only, never change, always stay positive and stay motivated. You see me, I say? I need everyone to realize what's going on with this case here that they claim that I stole a property from an 84-year-old lady, and this is all fraud. I'm going to give you all a time sequence of what occurred in this matter. On July 27, 2017, I went and did a race and nationality change in the Civil Supreme Court in Manhattan, 111 Center Street, and I was denied of my race and my nationality. I was changing it from them labeling me as black for me to be classified as my ancestral race as a Moor. Judge in the court by the name of Miss Sharp denied me of my race and my nationality, and that's a violation to the Declaration on the Human Rights, Article 12, and what happened is that Article 15 also. What they did after now, I appealed her decision to the appellate term at 60 Center Street on July 27, 2017. I appealed her decision. I got matter of fact, on July 27, I got a response back from the appellate term, 60 Center Street, by the name of Justice Shulman, granted my race and my nationality, because prior I did a name change in 2015, and it was granted already in 111 Center Street, but they were still classifying me as being black and not as my name and my race that go along with my name, Sage L. They were still classifying me black and African American, and these terms, that's a misnomer in the court of law.
All right. Forward to that. Let's discuss the situation that you're in right now.
All right. But I'm giving a timeline of what took place. This is a timeline.
Okay.
On the 27th of July, I got an answer on my petition, my race and my nationality, by Justice Shulman, July 27, 2017. But he also remanded the case back to the lower courts, that is 111 Center Street, on August 28, 2017. Back to that court. August 9, 2017. When I went to court on August 9, 2017, the judge that day told me that he don't want no part of this case. He's gonna adjourn it to August 28th to the same judge that denied me first, so she can sign off on it. On August 28th, when I went to court with two of my friends, the same judge, her name is Miss Sharp. When I went there, she denied me, even though it was granted from the higher court. She denied me again. And then she ordered 4 court officers to lock me up in the court after she denied me. Locked me up in the court. This is where the whole thing started from now. After she locked me up in the court, they transferred me from 111 Center Street in Manhattan to 120 Schermerhorn Street, the criminal court in downtown Brooklyn, with no warrant, no arrest record, nothing, no petition, nothing. I was transferred to 120 Schermerhorn Street. They brought up 2 old cases from 2016, brought up 2 old cases and charged me for resisting arrest and disorderly conduct in that criminal court in Brooklyn. After I was in jail now, this is August 28, 2017, I was in jail on that date for those so-called 2 charges, resisting arrest and disorderly conduct. Bail was set for $2,500 for me to be released. Finally, the bail was paid on the 29th of August 2017. I wasn't being released. They claimed that there was a grand jury indictment on me on the 30th of August, 2017. There was a grand jury indictment on me to keep me in Rikers Island, and I wasn't being released. And I was asking them, what is this charge about? What is this grand jury indictment about? Why I wasn't notified of a grand jury? Well, they told me that, well, if I want to know about the grand jury, I have to go to court on the 1st of September. I said, all right, I'll go to court. They brought me to court on the 1st of September, kept me in the bullpen under the jail, did not produce me in the courtroom upstairs in the court, or did not produce me to no court at all. And they brought me back to Rikers Island. They kept me there all, they bring me back. They did it the 1st, they did it on the 2nd, they did it on the 3rd, they did it all the first week of September. Never brought me to the court. On September 12th, they took me out, they brought me to court again, and the district attorney office came and took me from the custody of DOC, bring me to his office upstairs in the district, took me outside, walking me on J Street in prison clothes, handcuffed behind my back, embarrassing me on the street in open public, took me to the district attorney's office and asking me to give them fingerprint. And they're not disclosing to me what the charges are. So I said to them, how are you going to take me out of DOC custody for a charge I don't know nothing about? Y'all fraudulently create a grand jury indictment without giving me no opportunity to be present at the grand jury. I didn't have my counselor, nothing. When they was like, well, take it up with the legislator. They kept me in, they tried to give me a fingerprint in the district attorney office, and I refused. They brought me back to DOC custody again, and they sent me back to Rikers Island. This is the 12th. On the 13th now, they brought me back to court again on the 13th of September 2017. I refuse to give them fingerprint until I know what this charge is about, and I need to go in front of a judge to ask them, what is this charge about? They're not telling me. So what they did now, they took me out again on the 14th of September, bring me back to the court, let me know that they had a force order to force me to give them fingerprint. I said, well, if this jail or this court is not operating under a constitution, they cannot force me to do anything without my consent. I need to see a judge to find out what's this charge they're bringing against me. I don't have no idea. On the 14th now, they took me back from that courtroom and they throw me into the bullpen again under the court and have me sit there for like a good 20 minutes. Then they bring me back upstairs to a courtroom now in part 4 to a judge by the name of Matthew Demick. Matthew Demick, he's the chief judge of the court. When I went there on the 14th of September, he told him to bring me up to his bench. I went up to his bench, and he was like, sir, you need to get fingerprints so I can look at this case. So I said to him, but how am I going to get you fingerprint when I don't know what charge is bringing up against me? Who's bringing these claims? What is these claims about? He said, well, the DA is going to tell you what the charge is about, but you have to get fingerprints first. I said, sir, everyone has an opportunity to know what the crime is that they're being charged with. You cannot force someone to get fingerprints for a charge I don't know nothing of. He said, well, take it up with the legislator. That's his excuse. That same day, I looked at him and tell him, or he said, go back to the bench and the DA would bring forth this case. When the DA starts speaking on the record, the DA is saying that I stole the house from an 84-year-old woman.
What happened to the phone? Put the seatbelt on. Sage, are you there?
Yeah, I'm here.
Okay, yeah, go ahead.
Okay. On the 14th of September 2017, Frank Dudas, an ADA, starts speaking on the record in the court. And I said to the judge in the court, Mr. Demick, I said, on the record, let the record reflect. I don't know of nothing that this man is saying. And I clearly let him know that my name is Sage L, not Winston Hall. Winston Hall is a trust company it has 4 members in that trust company. And I also quoted a case, a federal case, Trinity versus Pagliaro. Counsel in brief or in oral argument when in line in the court is insufficient for summary judgment, clearly stating that when anything that this man says out of his mouth without an injured party is a violation to the federal constitution and to the state constitution. He's basically making an assumption on his own without a victim playing for injury in the court. So he's doing hearsay evidence in the court against me without me without no complaint filed against me by no victim. He's bringing forth all this claim in the court. So I object to what he's saying in the court on the 14th of September. I said, excuse me, my honor, this man is using hearsay evidence without a victim, and he's bringing forth all this claim without a complaint. What are you doing here? Is this a communist country? Is this an Article 1 court or an Article 3 court? The judge said to me, this is a court based off of the legislative enactment. So I said to him, but I need to have an Article 3 judge on this matter to see what this man is saying to be factual, because he's not saying nothing of facts. He has no sufficient evidence to what he's saying. He's using hearsay evidence. I don't even know what he's talking about. Well, he called me to his bench and said, if you give fingerprints today, sir, we're gonna move forward with the case. But if you don't get fingerprints, we're gonna send you back to Rikers Island, and we're gonna keep you there. We're gonna keep you there until they force you to give fingerprints. That's what they told me. He literally told me, we'll force you to give fingerprints. So I said to him, okay, under one condition I'll give fingerprints, under the Res Judicata Act of 1773. He said, what that is? I said, equity supersedes everything in at-law proceedings. So everything that you do to me after I give you my fingerprint is going to be an equity charge for every step of this proceeding. So he said, okay, no problem. Give them fingerprints and come back on the 14th, on the 18th. Come back on the 18th of September 2017, and then on the record you will be arraigned, and then you can plead not guilty, and we will release you. This is what he said on the 14th of September 2017. All right, they sent me back to Rikers Island. I was sitting there in Rikers Island with no complaint, no arrest record, nothing of such a sort, because I was already bailed out since the 29th of August, sitting in chair with no charge, no complaint, nothing, just because of the DA fabricating this claim against me. What went on now? On the 18th, I went back to court after the Monday, September 18th, 2017. When I went to court now,